The U.S. Supreme Court is deciding whether customers can sue Apple over accusations that the company has driven up the price of apps. Those customers' complaint is simple. They say Apple has an unfair monopoly and that developers mark up app prices to cover the 30% commission that Apple takes from sales. Domenic Romano is here. He's a business attorney and founder and managing partner for Romano Law. Is this happening, and is this actionable?
Well, there are two sides to this, obviously. There's a Supreme Court decision, 1977, Illinois BRIC, that says only the direct purchasers can bring an action for antitrust, which in this case, Apple is arguing, is the app developers and not the consumers. But Apple has a closed environment, unlike Google Play, where you can buy a Google app from various sources, Amazon, Google itself, or Samsung, or anyone else. Apple controls the environment, and the plaintiffs are saying it's resulting in the price of apps being driven up because Apple takes 30% of the price for the privilege of being on the app. And Apple can void a consumer warranty if you download an app on an iPhone from another source. And on the other side, for the developers, Apple can basically kick them off the system if they make their apps available elsewhere for Apple.
Huh. So there is a difference. I was going to ask you, so you go to a fair.
Right.
The fair charges space for the booth. You raise your prices to cover the price of the space. Therefore, the prices for the consumer are higher. This is different because? Because
the plaintiffs are arguing that the only place you can get the product is at Apple's fair, and Apple is controlling the pricing, only $1 increments. And Apple is controlling the environment. It's booting people out of the fair. It's controlling who the merchants that are come to sell their wares, who they're going to be.
But you're saying the issue is who has standing to bring the complaint.
Correct. Correct. That's the issue before the court.
And you could make the argument that the standing could be one of two different parties.
Yes. So Apple is saying that only the developers, because it's providing a neutral platform and the developers are showing up, and Apple is just a pass-through. It's just, facilitating a transaction. But the reality, the plaintiffs are saying, is very different.
Given the makeup of the current Supreme Court, how would you guess this might come down?
It will likely go the way the Amex case recently went, 5-4 in Apple's favor.
And do you find that to be the right decision, personally?
From a consumer perspective, no. And 31 state attorneys general agree. 31 states led by Texas. We got a Republican attorney general there, and Iowa, a Democrat there, are siding with the plaintiffs in the consumer's interests.
Domenic Romano, thank you.